Wisconsin has a well-defined breaking lease framework with specific statutory provisions that provide more clarity than many states. The governing law is found in Wisconsin Statutes, Chapter 704, which covers landlord and tenant relations, along with Wisconsin Administrative Code ATCP 134, which provides detailed consumer protection rules for the landlord-tenant relationship. If you're a landlord or tenant in Wisconsin, the combination of statutory law and administrative code creates a framework with specific obligations on both sides when a lease is broken early. Let's start with the landlord's duty to mitigate damages, because Wisconsin has one of the clearest mitigation requirements in the Midwest. Under Wisconsin law, when a tenant breaks a lease and vacates before the end of the term, the landlord has a duty to make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit vacant and hold the departing tenant liable for the full remaining rent. Wisconsin's mitigation requirement is well established through both statute and case law. The landlord must take the same steps to re-rent the unit that a reasonable landlord would take to fill any vacancy, including advertising, showing the unit, and accepting qualified applicants. If the landlord fails to make reasonable efforts, the departing tenant's liability for remaining rent can be reduced or eliminated. The departing tenant's liability is generally limited to rent for the period the unit remains vacant, despite the landlord's reasonable re-rental efforts, plus any reasonable costs the landlord incurs in re-renting, such as advertising expenses and the cost of cleaning or preparing the unit for a new tenant. If the landlord re-rents the unit quickly, the departing tenant's financial exposure is minimal. Wisconsin's Administrative Code, ATCP 134, adds important consumer protection provisions that affect the breaking lease process. Under ATCP 134, landlords must follow specific rules regarding security deposits, move-out procedures, and damage claims. These rules apply when a tenant breaks a lease just as they do at the end of a normal tenancy. The landlord must return the security deposit or provide an itemized statement of deductions within 21 days of the tenant vacating. One important aspect of Wisconsin law, ATCP 134.06, prohibits certain lease provisions that are considered unfair. A lease provision that requires the tenant to pay the entire remaining rent as liquidated damages upon early termination without accounting for the landlord's duty to mitigate could be challenged as an unfair provision under the Administrative Code. Early termination fees must be reasonable and cannot function as a penalty that exceeds the landlord's actual damages. This doesn't mean early termination clauses are unenforceable in Wisconsin. It means they must be structured fairly. A clause that allows early termination with reasonable notice and a fee that approximates the landlord's actual expected damages, such as 1 or 2 months' rent, is generally enforceable. A clause that imposes a punitive fee of 6 months' rent, regardless of how quickly the unit is re-rented, is more likely to be challenged. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Active duty service members who receive qualifying orders, permanent change of station, deployment of 90 days or more, or orders to move into government housing can terminate by providing written notice with a copy of the orders. The lease terminates 30 days after the next rent payment is due. No early termination fee or penalty can be charged. Wisconsin has enacted specific protections for victims of domestic violence, sexual assault, and stalking that allow early lease termination. Under Wisconsin Statute Section 704.16, a tenant who is a victim of domestic abuse, sexual assault, or stalking can terminate the lease by providing the landlord with written notice and documentation, which can include a copy of a protective order, a condition of release, or a criminal complaint. The tenant must provide at least 28 days' notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 21 days with an itemized statement of any deductions. Wisconsin's domestic violence lease breaking provision also includes protections for the tenant's privacy. The landlord must keep the documentation provided by the tenant confidential and cannot disclose the tenant's status as a victim to other tenants, future landlords, or anyone else. Tenants in Wisconsin may break a lease if the landlord fails to maintain habitable conditions. Wisconsin Statute Section 704.07 establishes the landlord's duty to maintain the premises in a reasonable state of repair. If the landlord fails to address serious habitability issues after receiving proper written notice, the tenant may have grounds to terminate based on constructive eviction or material breach of the lease. The tenant should provide written notice identifying the specific habitability issues and allow the landlord a reasonable time to make repairs, typically the statutory time frame of a reasonable period given the nature of the repair. If the landlord fails to act and the conditions are serious enough to substantially affect health, safety, or the ability to use the property, the tenant can terminate and is not liable for remaining rent. Wisconsin also has specific provisions regarding the tenant's obligations when breaking a lease. If the tenant abandons the property, leaves without providing notice or returning keys, the landlord can treat the lease as terminated and take steps to re-rent. Under Wisconsin Statute Section 704.05, the landlord can enter the property and remove the tenant's personal property after providing proper notice. The tenant remains liable for rent through the date the unit is re-rented or through the end of the lease term, whichever comes first, subject to the landlord's mitigation duty. From a practical standpoint, Wisconsin's rental market dynamics vary significantly across the state and affect how breaking lease situations play out. In Madison, where the rental market is tight, driven by the University of Wisconsin and state government, landlords can typically re-rent quickly. Madison's market operates heavily on an August-to-August lease cycle tied to the academic calendar, and units that become available during peak rental season are absorbed rapidly. A tenant who breaks a lease in spring or early summer may face minimal financial exposure because the landlord can fill the unit for the fall. A tenant who breaks in October may face more liability because mid-year vacancies in a student market are harder to fill. Milwaukee has a more varied market. Desirable neighborhoods like the 3rd Ward, East Side, and Bayview have strong demand, while other areas may take longer to fill. The re-rental timeline directly affects the departing tenant's liability. Green Bay, Appleton, Kenosha, Racine, and other Wisconsin cities have moderate markets where re-rental times vary by neighborhood, condition, and season. The university markets, Madison, Milwaukee near UWM, La Crosse, Eau Claire, Stevens Point, and Oshkosh near their respective UW campuses, all operate on academic cycles that affect the ease of re-renting mid-lease. One best practice for Wisconsin landlords: include a reasonable early termination clause in your lease that complies with ATCP 134. Structure it as a specific notice period, such as 60 days, plus a fee that represents a reasonable estimate of your re-rental costs and expected vacancy period. Avoid punitive fee amounts that exceed what you'd actually lose. Wisconsin's consumer protection rules can invalidate unfair provisions. Another best practice: begin your re-rental efforts immediately when a tenant provides notice of breaking the lease. Document every step: when you listed the unit, where you advertised, inquiry counts, showing dates, and when you accepted a new tenant. Wisconsin courts take the mitigation duty seriously, and your documentation proves you fulfilled your obligation. A third best practice: have a standard process for handling domestic violence lease terminations under Section 704.16. When a tenant provides written notice with qualifying documentation, accept the termination. Calculate the date 28 days from notice, handle the security deposit according to standard rules, and maintain the confidentiality of the tenant's documentation. Training your staff on this process ensures compliance and protects the tenant's privacy. Wisconsin requires landlords to return the security deposit within 21 days of the tenant vacating, regardless of whether the departure was a normal move-out or a broken lease. The same itemization and documentation requirements apply. Failing to comply with the 21-day timeline can result in the landlord forfeiting the right to retain any portion of the deposit, plus potential liability for double the amount wrongfully withheld. For the complete guide to Wisconsin breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.